Hi everyone, it's Ladybug here, and we are going to continue with Dexter Lawson's trial. We are going to start with the closing arguments and then go on to the verdict. And let's get started. Here we go.
Order the court on rise, sir. Court for Gadsden County, I'm Judge Marsh, now for that.
Hey, good morning, everyone. Please be seated.
Good morning.
All right, we're back this morning in case number 2021-388 CFA State versus Dexter Lawson. You should see on your desks I put out final jury instructions and verdict form. During the evening I did make a couple of changes that we had not discussed, so I just wanted to put those on the record. The first is on page 1. I changed it from grand theft of a motor vehicle just to theft as we have captioned it. I'll note that previously where we had the reclassified language, I just made that interrogatories to separate the charges and lesser includeds themselves from the interrogatories.
Yes, sir.
On count 3 theft, page 13, I made it an 2A or B, commensurate with the statutory provisions.
Yes, sir.
And then the pro se defendant, I moved it. It's the instruction's still there, but it was in the middle of talking about witnesses, and I didn't want it to be confusing about defendant and being a witness. I go into all the witness stuff first, then I put it right before rules for deliberation, or right before rules for deliberation, because that's a factor they are not to consider, whether, positively or negatively that he represented himself. And I think those are the only changes made.
So we're actually going to skip to the best part, which is Dexter's closing statement, since mentor lawyer already went over the state's closing. So we're going to get back to it.
Not because you're angry at somebody, not because of prejudice, not because of what's happening anywhere else outside this courtroom, but because justice in this courtroom. Where we talked, if nowhere else in society, in this room, we will endeavor to make sure that there's justice for Prince and Papa, law enforcement and civilian. Justice is guilty as charged. Thank you.
All right. Mr. Lawson, you may argue.
Democracy is the people in power. If the people in power, that means that it's y'all decision, okay? But y'all don't know law, so it's up to y'all at the end of the day, okay? You gotta be able to presume I'm innocent and to prove I'm guilty, okay? Prove that to me. They gotta be able to prove that beyond a reasonable doubt. They gotta say, I know for a fact that's me, right? Also, you gotta say, I know for a fact that I possessed the gun. Not just any gun now. You gotta be able to prove beyond a reasonable doubt that I possessed a Glock 45 that did what they trying to say that I did. They said earlier that it gonna show that I shot 6 times into a police car. First, you gotta tell that to me. First, then you gotta also really prove that I had a Glock 45. Okay, you got the deputy. She said that I run away and I turned right around and I ran towards her, and then I started shooting. Right, but yet I'm very describable. Like my beard, okay, my head, how I look, what I had on, okay, all that plays a factor in Hardee identify. First, you gotta identify who was shooting at you, because you can assume who's shooting at you, but how you gonna say I know for? She said she don't know for a fact I shot her. Okay, how you gonna be able to prove beyond reasonable doubt that I had a Glock 45? Okay, can you play the ramming video?
Yes, sir, right here. From the beginning.
Yes, sir. Can you start right now?
Sure, sorry.
Can you back up a little bit?
Sure. Tell me what
Right
you
now. All right, go back. Come back.
forward.
Come back. Come back. Reverse. Not go forward. Go back.
Okay.
Come back. Right now.
Right there.
All right.
Okay.
See how close that is? That's real close right there. You ain't gonna not go.
Just pull it. You want me to play it real speed?
Just on this play.
Yes, sir.
She pulled in front of me. How you gonna be able to prove that I wasn't attempting to flee? How you gonna be able to prove that? I mean, she pulled in front of me. Okay, okay, the democracy is the people that are supposed to be in power. How could the people be in power if the people in power, that means the people is the superior when it comes to the government, because the government is supposed to work for the people, right? Okay, but how the government is set up is like they reversing it. Instead of them, we work for them. Instead of them working for us, we work for them, right? But how you gonna be able to prove beyond a reasonable doubt that I possessed a Glock 45 and I did that, and you ain't got no fingerprint, no DNA on the gun. You got this lady saying that she's seeing a tall individual. I'm not tall at all. She said a tall individual with a tan uniform on, right? Okay, she never said, oh, he had on gloves. She never say, oh, he had a beard. She never say he had a big head. How you gonna miss that if you seen me shoot 4 times? You seen me shoot 4 times, but at the same time, you ain't saying about no blood, but yeah, you know exactly what color I got on. If you know what color I got on, how you gonna miss the fact that I got on gloves? How you gonna miss the fact that I got a beard? How you gonna miss the fact that I got a big head? That's very distinguishable. When they called the police, nobody could identify how I look. Okay, the other dude, when he testified, okay, he said I had on a checkered t-shirt, right? A checkered shirt. Okay. How many checkered shirts out there? I had on a tan jacket. Okay. Then you say, okay, first he say, I had on a blue shirt. Okay. Now, you see me when I got on blue shirt, but you could have seen me when I had on blue shirt when I got in the police car. It's not mandatory that you seen me with a blue shirt on at that time, because for one, you missed the jacket. I got on a jacket. You said a checkered shirt. That could have been anybody. Okay, due to the fact that Debbie Hearn cannot say she know for a fact that I shot her, anybody could have shot her. Anybody could have did that. So if you gotta be able to presume that I'm innocent and to prove me guilty, how you gonna say I know for a fact that I possess the Glock, because the Glock 45? Can you show the woman?
Sure. The window? Yes, sir.
How you gonna be able to prove I did that? It doesn't show that I did that. And then she said, okay, the thing about the situation right here, right? The state get all the evidence, they get everything, and they would, and get what I get. I don't get nothing, right? But the state get all the evidence. and they talking with law enforcement and everything. So they can pick and choose what to present and what to leave out. That's an edit. I know for a fact that a lot of officers had body cam and not even presented it that they had body cam, right? And if it's not in the state favor, they ain't gonna present that right there. They gonna edit. They gonna take some out. They gonna add this, and when you run it, it's like a movie. It's just like a movie. Even a movie look real. Okay, they say the smoke, right? Okay, but you manipulating the video. You was manipulating the video so much, you can look. It can look like I did something and didn't even do it. Okay, they said I was the only one on the scene, right? Prove I was the only one on the scene because nobody can identify how I look, and I'm very distinguishable. I got this beard. That's why I wanted to go ahead and go try because I got this beard. Like, you can't tell me once you see me, you forgot how I look. You can't do that. You cannot say, oh, that's Dexter Antonio Lawson. You know Dexter Antonio Lawson when you see Dexter Antonio Lawson. So even the fact that you can say I was moving in a certain direction, okay, when you got this lady saying that it was a tall individual that shot 4 times, she said I shot not 1, not 2, not 3, but 4 times. And you not knowing how I look, you said, okay, I don't got on no uniform. I got on a jacket. Okay, she never even said nothing about no gloves. Then her don't even say nothing about no gloves. Nobody said nothing about no gloves. Okay, how you see my shirt if I'm running away and I got on a jacket? Okay, the state gotta be, the country of this state will not allow anyone to be sanctioned on a provision on speculation, intuition, or hunches. But yet it's full of intuition, yet it's full of hunches, yet it's full of speculation. Because how you gonna say I shot you, but at the same time you don't know for a fact, right? Okay. How you gonna miss the fact I got on gloves? You don't know who shot you, right? Okay. None of the witnesses identified me. I was identified solely on the camera, right? Okay, but yet the camera does not show nothing. I done seen a lot of situations that done transpired where they had more than enough evidence and never prosecuted that situation, period. So at the end of the day, how can you prove that I tried it? Okay, she pulled in front of me. Like she pulled in front of me. So therefore, how you gonna be able to prove that I tried to kill her? How you gonna be able to prove that I wasn't trying to flee? Okay, then you got a video of me saying anything in the bite seat, but at the same time, that has nothing to do with the evidence at hand. That has nothing to do with the act. Okay, first, not only they gotta be able to prove it beyond a reasonable doubt that I was on the scene, they also gotta be able to prove beyond a reasonable doubt that I committed a whole act. You gotta be able to prove that I committed a whole act. How you gonna be able to prove that I committed a whole act if it doesn't show what was shot? The country of this state would not allow anyone to be sanctioned on a provision on speculation, intuition. They asking y'all to speculate. They asking y'all to use y'all intuition, y'all hunches on something that they edited. Like a movie. Like, even movies look real. This is 2020. You can easily manipulate a video to the point where it'll come out looking just how you want to look at it. And you got all of them directing that round table. You got, okay, the law enforcement, they get all the evidence and they pick and choose what they want. Then they talk about it. But at the same time, put it on national news. Marsh on national news, say Dexter Antonio Lawson did that beyond reasonable. Prove that Dexter Antonio Lawson did that beyond reasonable doubt. Okay, direct evidence is proof. Okay, you got indirect evidence. Indirect evidence, which is speculation of evidence, right? But you got on national news, you say that I did that, right? Okay, now you gotta be able to prove that. Because at first, he said that. He said, oh, it's gonna show that Dexter Lawson jumped out came back and shot 6 times in a police car. It doesn't show that at all, right? Okay, and then how you gonna be able to prove beyond reasonable doubt that I had a gun? Okay, hold on now. So, okay, this is not premeditated at all, right? Okay, when Deputy Hearn pulled in front of me, right, she put on the light, right? This is not a plan. This is just straight dumb. I mean, I'm off medication. You know what I mean? I'm like, okay, it's a trigger. I've been locked up a lot of times. You know what I mean? I've been through a lot of different things. So therefore, that's not a trigger. I got a million of ways that it could be a trigger, but yet I was told not to talk about Breonna Taylor and all the other stuff. You know what I mean? But okay, how you gonna? He said, I'm so happy. I'm drinking. I ain't nothing. Okay, but that has nothing to do with that. This not being premeditated. This is not being premeditated. This is a dumb situation that I put myself in. Like, how you gonna be able to prove that I tried to kill her? It was just something that happened. How you gonna be able to prove that I wasn't trying to flee? That's if you gotta be able to prove. If you gotta be like that. The thing about spades, you can make the rules, but you ain't no one can win from them rules. Like you gotta be able to go. If they can't. This is their law. They law say that you gotta be able to prove beyond a reasonable doubt every element. Beyond a reasonable doubt every element, right? So you saying, okay, this is what I mean by that, right? Okay. The professional got out here yesterday and she said, okay, the DNA could be destroyed when a bullet is fired, right? But what about the other bullets that was in the clip? Like, okay, so I understand. Okay, if you're saying the bullet that was fired, okay, that ain't got no evidence on it. They ain't got no DNA on it. But what about the rest of the bullets that was in the clip? Why? I know they did it. I know they dusted every single bullet, everything. They got a million pictures. Ain't no way around the fact that you can't connect me to that gun. If you can't connect me to that gun, and you got to presume that I'm innocent and to prove guilty because it done been too many times that they done broke rules and bent rules and got away around the rules when it pertained to certain people. But I was told not to get into all of the different political things that is public information. Like you say I got freedom of speech, but yet you tell me
Sidebar. Mr. Lawson, is there any reason that after this court tells you what you can't get into, that you turn around and tell them that you can't get into it, and then you start getting into it?
I got a freedom of speech to say. You told me not to get into detail about that particular thing. Only thing I was just making it known as in my defense, too. I mean, all due respect.
No, sir, I'm not going to let you talk about politics and people getting away, and I can't tell you about national events, but you know about national events. I'm not going to let you do it. You've done plenty of other good things. You've talked about the fact that they didn't look for DNA on the unfired rounds. You've talked about that the video doesn't show 6 shots. You've done a great job pointing out deficiencies. I'm just not letting you go down the political road of talking about national news events. The other stuff you're doing is perfectly valid argument, and you're doing just fine. If you stay with talking about the facts of this case and what the state is not able to show, that is fine, and I'll let you keep doing that. But I'm not going to let you, especially when you acknowledged you weren't supposed to go into it, and then you went into it anyway. Okay?
Yes.
All right, step back. All right, Mr. Lawson, you may proceed, sir.
It's just the rules, right? The rules simply is plain and simple. Like if you said I gotta be able to prove beyond a reasonable doubt, if the state gotta be able to prove beyond a reasonable doubt every element, not only do they gotta be able to prove that I was on the scene. They gotta also prove beyond a reasonable doubt every element of a whole act. Okay, it's a lot of stuff that they just ain't even displaying. The only thing they is displaying is the thing that is not in my favor. Okay, but when you put all type of okay, how is it a crime for me to take off my clothes? This is not a crime for me to take off my clothes. Okay, prove I had that gun though. Prove I had that particular gun that shot 6 times when you got the deputy cannot say she know for a fact that I did that. And then if you know me, if you've seen me before, you'll never forget how I look. So that right there, in the fact that you got all the witnesses. Okay, you got 4 different witnesses that was on the scene when that happened. Okay, I stayed in Jackson. So you know how other people stay, a lot of people stay in Jackson. So when you say that, oh, I was on the one on the scene, that's a lie because you got all kinds of people on the scene. And but at the same time, you don't know how I look. Like it's a video that I tried. Cause thing is, they got body cam. They got body cam. A lot of them got body cam, but thing is, it's not beneficial to let them know that okay, we ain't gonna show it if it's not beneficial. If it's gonna favor him, we ain't gonna show it, right? But at the same time, nobody know how I look. How can you not know how can you say I'm running at you, then say you don't know how I look? You cannot. And then when Ms. Rodriguez got on the telephone, called 911, Ms. Marsh got on the phone and told him how many times that she got shot, but at the same time, you can't say that you can't say who shot you. I mean, and at the same time, you gotta be able to presume I'm innocent and to prove it guilty. All right, how you gonna be able to approve that and it doesn't show what y'all saying that it shows? You know what I mean? That's the crazy thought about the whole situation. It's like, okay, with the terrible evidence, okay, I took off my clothes, but at the same time, I stayed down the road. Like it makes no sense for me to stay down the road and did what I did. Like if I know for a fact that I did that, you know what I mean? So when the terrible evidence, it's not what evidence that I tamper with. Okay, I don't own that gun. Never seen the gun before. The gun is not mine. How you gonna be able to prove that gun mine? And if you know got the gun on me, you find the gun in the wood. Anybody could have had that gun. So how am I telling with evidence when the gun? I don't know nothing about no camera in no truck. You see what I mean? I don't know nothing about no camera in no truck. I have no recollection of no camera in no truck. So therefore, it made no sense to me. And then the gun situation, right? Okay, they said evidence of value, fingerprints of value, but they ain't say the gun was completely clean. When they say they swore that gun and everything, okay, the gun was still the gun had DNA on it. The gun had DNA on it. It had fingerprints on it. So due to the fact that it didn't match with me, they saying, oh, y'all can't. By y'all finding me guilty on attempted murder, that automatically assumed that I had a Glock 45. Okay, but think about it like this. Look at it another way, right? Okay, they right, look at it like this, right? Okay, if the fingerprint was on it, if my fingerprint was on the gun, then that would have been proof. They would have been able to say they can prove aggravated battery if my fingerprint was on that gun. Due to the fact that ain't no fingerprints on the gun, and they saying that that's the only gun that was used, you trying to speculate, you use the intuition, and you use the hunches to say, oh, even though the fingerprints ain't on the gun, Dexter Lawson still had a gun. But at the same time, how you gonna say Dexter Lawson had a gun? You gotta at the same time prove, you gotta be able to presume that I'm innocent, right? Until they prove beyond a reasonable doubt that I'm guilty. That's the impossible burden if you can't prove that I had the gun. Like you, not only you okay, even if you say that's me or whatever, right? Okay, you saying that it shows that I shot 6 times into a police car. Like, you ain't asked Dexter Antonio Lawson who did it. No, you said Dexter Antonio Lawson did it. You went on national news and you said Dexter Antonio Lawson shot 6 rounds into a police car. And it's in the newspaper. This on Facebook. It's on Instagram. It's everywhere. So, and then you got a trial while I'm in Quincy. So, I mean, why is you doing all that if you got the proof? They don't even display the bullet. They don't even display the gun on the news. Like, they know because they ain't got no fingerprints on the gun. How you gonna be able to prove beyond a reasonable doubt that I had a gun and it's not my fingerprints on the gun? Okay? By you saying that I had on gloves, right? Okay. By you saying I had on gloves, that don't change the fact that my fingerprint on the gun, you can't prove premeditated murder, premeditated first degree attempted murder, right? You can't. Okay, this is not a plan. This is just something that transpired. I know nothing about a video. I don't know no camera and no truck. Okay, so it's like they don't got all the evidence. You paint a picture without proof. Then you saying that, okay, oh, even though he ain't got ain't no fingerprints on the gun, it's a possibility that he still had the gun. No, if I touch that gun, I'm grabbing that gun. If this is my gun, I'm grabbing that gun. I ain't got no gloves on while I'm grabbing the gun as mine. Okay, who would say the host of mine? You know what I mean? It just you can say what you want to say, but if you have no proof, cause it's 3 sides of the story. It's my side, your side, and the truth. Okay, and if you set the rules and you say, okay, you need proof. Beyond the proof is direct evidence. Proof is direct evidence. Proof is I know for a fact that he did that. Anything outside of proof is speculation, intuition, circumstantial evidence. That's anything outside of proof. And you say proof beyond a reasonable doubt. That means that more than proof. You know what I'm saying? Okay, you got less than proof. You got circumstantial evidence that, and you got also prove that I was on the scene. Okay, yeah, I was on the scene, but you got to be able to prove beyond a reasonable doubt that I did what y'all said I did. And with the ramming, okay, how you gonna be able to prove that I wasn't trying to flee? How you gonna be able to prove beyond a reasonable doubt that I tried to kill her with a car? Man, y'all can see that the truck and the car wasn't even that far apart. I ran my case.
All right, State,
Thank
you
you.
may present rebuttal.
Mr. Lawson talks about a lot of things that the state doesn't have. I would ask you to focus what the state has brought. The state, certainly, if you look at the evidence in this case, any suggestion that Ms. Coggins wasn't being candid, I think you all had the opportunity to hear her. She became incredibly emotional on the stand. She explained to you that this was the scariest thing she had seen in her life and that she was still upset about it today. There was no question in her mind that the person that was shooting, she didn't even know was shooting at a deputy sheriff, that whoever it was, whether they were trying to kill a snake or a dog, that they were trying to kill them. That is direct evidence. The fact that Stephen Foxwell sees a man running in a red check shirt. He's a little further down the road. You recall he's the lawyer, retired lawyer, got a cane. How in the world does he know that there's anyone involved in anything? But he sees someone running through the neighborhood, first with a red shirt, and then now it's changed to a blue shirt. There was some conversation about, well, could it have been? Well, I guess it could have been 2 people, but I know beyond a reasonable doubt it was one person, and that person had a red shirt and a blue shirt. That's why we have trials where we organize. You met Amy George. We collect all the evidence. Sometimes it's relevant and sometimes it's not. Sometimes it supports and sometimes it not. Ladies and gentlemen of the jury, here I would suggest to you, you have both direct and circumstantial evidence. You've got the video, which is extraordinary. Corporal Officer, I told you, I never get to see something like this. But you heard, and that's why we presented it to you, that he wasn't allowed to see the video until yesterday because he needed to make his conclusions based on the science of what happened with that truck. And that truck crashed into that car and drove it for 103 feet. He can show you the gouges in the asphalt. He can show you the debris trail. He can show you, and it was supported by the black box. That's another circumstance piece of evidence that shows that he was throttling the driver of that truck at 99%. It took a couple seconds, and then that truck was giving. Defendant continues to argue that, well, if I had been a little bit further, I would hit her a little harder. Ladies and gentlemen, I would agree. Thank goodness you weren't. You hit her hard enough. Defense argues that we should, for some reason, expect more of Deputy Hearns. That she had not done her duty that day, that she should have also been able to identify him as he shot her. I would suggest to you that Deputy Scar Hearns did exactly what we asked her to do each and every day as a law enforcement officer. In a moment, her life went from peace to battle. In a moment, she was hit by airbags exploding in her face and getting hit by 9mm rounds. Probably the most compelling thing about the character of that woman is when she did get into the Rodriguez's. Remember, as they came and tried for an aid, she said, "Don't come out here." She knew the danger that was still lurking in the woods. The defendant argues that because I can't sit there and zoom in and show the colors of his creases of his face while he's pulling the trigger, the evidence does not.
How was it? Misleading the jury.
Overruled.
Ladies and gentlemen of the jury, you have evidence clear and beyond any reasonable doubt that the man in the red shirt with the red gloves is sitting at defense table, that he stole that truck, that he drove it, and then he decided to run over that deputy. He's the same one that gets out and runs away. It's the exact same person. It doesn't make any sense. He asks you to force, imagine, speculate it down. It only is consistent because despite his argument, there were others who identified him. The people who pulled him out of the bushes as he ran through the woods. Let's not forget, at the end, despite getting rid of his jacket, despite getting rid of his gloves, despite casting the gun into the woods, despite getting rid of everything that he knew would hold him accountable for his choices, he still has that memorable face he talks about. And each of those officers said, "That's the man who came out of the wood line. That's the man that my dog tracked from the driver's door of that truck through the woods on over a quarter mile, 0.35 miles, to the foot of Dexter Lawson." Dexter Lawson made some choices on November 16th. Thank goodness he failed. Thank goodness, but it doesn't mean that you should. Justice must be had. His decisions to ram her, his decision to try to bring an end to her life, his decisions to start shooting. You could see the 6 bullet holes in that car. Now, I've been a lot of evidence, and I kind of want to give you a little bit. A lot of this we never opened in package. We used pictures. You all, it's in evidence, so you guys could actually dig into it. But there's some glove issues. So the pictures are going to go back with you. The foam boards are going to go back with you. But we can't send a computer back because like the judge says, you can't go and do Googles on this stuff. So as you are doing back, if you'll write a note, we can let you come in and we can open. You want to see the bullets in her vest? We can show it to you. If you want to sit there and open every glove, we can open it for you. But at the end of the day, ladies and gentlemen, I'm confident that you all have seen the truth. That's what verdict stands for. It's Latin. Veris dictum, speak the truth. The truth is that Dexter Lawson is guilty of trying to kill Shakara Hearns with his truck. Not his truck, the McNeil truck he had stolen. He's guilty of trying to kill her dead by shooting her with a pistol. The same pistol that's forensically proven to be the shell casings outside. The same pistol that's cast into the woods along the trail he ran. And that as he cast that gun,
you haven't proved, he's speculating.
Overruled.
he's guilty of tampering with the evidence that proves his crime is fatal. Come back with your heads held high, knowing that you've done justice. Come back with a verdict of guilty as charged. Thank you.
Now, in just a few moments, you will be taken to the jury room by the bailiff.
Okay.
The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Now, I'll go off script here. Normally, I've allowed you to have your cell phones and things like that with you during the breaks. When you go back to deliberate, the deputy will take custody of those and safeguard them for you. So you can't have cell phones, or even if you have an Apple Watch, any smart watches, anything like that, you'll need to turn them over to the deputy, and the deputy will safeguard them for you during your deliberations. Now, if you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the parties before I answer, so it may take some time.
So give me 1 second.
You may continue your deliberations while you wait for my answer.
Order in court, all rise. Court is now back to session.
Everyone, please be seated. All right, we have a jury question, and the question is as follows. We would like to see the video of the actual shooting. So the court's going to interpret that it would appear to be State's Exhibit 1. There's a clip that shows
Yes, sir.
an individual exit a vehicle, run away, come back. What the court is obviously not deciding. That's for the jury to decide. But what could be construed as someone firing a weapon, and again, ultimately that's this jury's call. That would be what the court expects they're talking about. So if we can get that queued up.
We're doing it now, sir. Also, the court reporter was asking me for a site that the court, and I just don't remember the specific spelling, for the standard jury instruction concerning hitting a vehicle, counting. I don't know.
Oh, it is Clark.
That's Clark v. State. And then there's Fay, which is the one that the court, F-E-Y, that the court did not give, correct?
Correct.
Okay. I was just trying to give her the spellings.
Thank you very much.
All right, then if we think we've got it queued up and ready, let's see that.
Yes, sir, I can.
Well, I want to play. We'll play it in its entirety. I don't want to necessarily queue it up to a certain point. If that is the video that contains that portion.
This is it, and if the whole length of it's 1 minute, sir.
That's right.
And
That's why we'll play the whole thing.
Yes, sir.
If they want to ask for a specific portion, we'll address that.
Yes, sir.
All right, we ready to get the jury?
Yes, sir.
All right, let's bring in the jury.
All rise for the jury.
All right, ladies and gentlemen of the jury, you may be seated. And ladies and gentlemen of the jury, I got your note regarding wanting to see a video containing an actual shooting. So we have queued up State's Exhibit 1, that portion in its entirety, and it will be played for you at this time. State, go ahead. All right, ladies and gentlemen of the jury, does anyone need that played again?
Can we request something?
Yes, ma'am, go ahead.
Can we see it closer?
Yeah, I think that's fair enough. Then what I'd like to do, Mr. Campbell, if we can move that screen closer to the jury box.
Yes, sir. Close enough? Sorry, I'm behind it, so all right.
All right, Mr. Campbell, just take a second to make sure, as that obviously has to repower the
Sure.
TV. Sometimes the inputs change around a little bit.
And then, can we ask the president at a specific point?
Well, let's watch it again in its entirety, and then we'll deal with that issue.
Your Honor, I can see it on this screen, even though I'm around the corner. So if they tell me, I'm
Well,
driving.
I just want to play it in its entirety, and
Yes,
then
sir.
we'll deal with that. Do we need to do any specific others?
I think we're fine.
Okay, with that, ladies and gentlemen of the jury, you may return to the deliberation room to continue your deliberations.
All rise for the jury.
All right, the jury has departed the courtroom. The court will be closed for deliberations.
Order to put all rise. Circuit court is now back in session.
Everyone, please be seated. My understanding is we have a verdict. Are we ready to call in the jury?
Yes, sir.
All right, let's call in the jury. That's why I made sure you had it. Don't let me leave with the verdict form. I've got a notorious habit of that.
All rise for the jury.
All right, ladies and gentlemen of the jury, you may be seated. Everyone else may be seated. Juror number 4, are you the foreperson?
Yes.
I think you're, again, I don't have my numbers here in front of me. Has the jury reached a verdict?
Yes, we have.
Please hand the verdict form to the bailiff. The verdict appears to be in proper form. I will now publish the verdict. In the Circuit Court of the Second Judicial Circuit in and for Gadsden County, Florida, State of Florida versus Dexter Lawson, case number 2021-388-CFA. Verdict. Count 1, attempted first-degree murder, vehicle. We, the jury, find as follows as to count 1 of the information. The defendant is guilty of attempted first-degree murder. Interrogatories, count 1. Has the state proven beyond a reasonable doubt that CH was a law enforcement officer? Yes. That the defendant knew that CH was a law enforcement officer? Yes. CH was engaged in the lawful performance of a legal duty? Yes. During the commission of the offense, did Dexter Lawson personally use a weapon? Yes. Count 2, attempted first-degree murder, firearm. We, the jury, find as follows as to count 2 of the information. The defendant is guilty of attempted first-degree murder. During the commission of the offense, has the state proven beyond a reasonable doubt that CH was a law enforcement officer? Yes. The defendant knew that CH was a law enforcement officer? Yes. CH was engaged in the lawful performance of a legal duty? Yes. During the commission of the offense, did Dexter Lawson personally use a firearm? Yes. During the commission of the offense, did the defendant personally discharge a firearm? Yes. During the commission of the offense, and as a result of the discharge of the firearm, was great bodily harm caused to CH? Yes. During the commission of the offense, did the defendant actually possess a firearm? Yes. Count 3, theft. We, the jury, find as follows as to count 3 of the information. The defendant is guilty of theft. Interrogatory. Has the state proven beyond a reasonable doubt that the property taken was a motor vehicle? Yes. Count 4, tampering with physical evidence. We, the jury, find as follows as to count 4 of the information. The defendant is guilty of tampering with physical evidence. So say we all on August 24th, 2022, signed by the 4th person. Does either party wish to have the jury polled?
No, Your Honor.
Mr. Lawson?
No.
All right. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who wish to seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Ladies and gentlemen, thank you for your service. Again, you are excused from state jury service for 1 calendar year from today. If you get a state jury summons, just call the clerk's office and they'll take care of it. If you get a federal jury summons, sorry, you'll have to talk to Judge Walker about that one. But with that, I will have everyone else remain here in the courtroom for the departure of the jury. With that, ladies and gentlemen of the jury, you may depart the courtroom. A bailiff will escort you.
All rise for the jury.
The jury has departed the courtroom. Everyone may be seated. Dexter Lawson, you have been found guilty by a jury of Gadsden County members of 1 count of attempted first-degree murder of a law enforcement officer under count 1, under count 2, attempted first-degree murder of a law enforcement officer, under count 3, grand theft of a motor vehicle, and under count 4, tampering with physical evidence, and a judgment of guilt has been entered against you. With that, sir, you have the right to have an attorney represent you in sentencing, and if you cannot afford an attorney, I can appoint one to represent you. Do you wish to have counsel for sentencing?
Yes, sir.
All right, with that, I'm going to appoint the Office of the Public Defender to represent you in that sentencing. Do we have one of the members of that office at least enough to step up and we can push this out a ways?
Yes, Your Honor. I put them on notice that that might happen. I'm fine whenever, as far as calendaring. I don't know if you, I know you're in the Leon bench. If you'd rather do it there, my anticipation is that the defendant will again be moved back to the Leon County Jail as soon now the verdict's over. So I'm really I'm generally in Leon, so whenever it's convenient for her, I'll be ready.
And counsel, if you'll go ahead and announce your appearance for the record.
Darlene Rollins, Assistant Public Defender, Your Honor.
Thank you, Ms. Rollins. So folks, calendaring wise, Ms. Rollins, I mean, it would actually seem proper for this sentencing to remain in Gadsden County.
I'm happy to come over. It's just whichever. I'm fine. We'll have to transport him over for that. Candidly, and I know Ms. Rollins, she was the same assistant public defender who represented it before. With the verdicts on count 1, count 2, with the PRR, and with it's a minimum mandatory sentences. So I'm at her leisure when she's ready.
And understood. And again, with some of the writings of the defendant earlier, there may be some things she needs to look at in her office, and I want to give her the time to do that. If there are in fact conflicts, I don't know if there are, but I do need to give counsel the opportunity if there are conflicts. We want to make sure that Mr. Lawson has conflict-free counsel. I'm not saying there is a conflict, but I have to give counsel the opportunity to look into that matter as well. With that, I don't have the. Why don't we do this? Why don't we set this out? Do we Ms. Rollins, could we do this? You know what we could do? We could do it by Zoom, because we can Zoom him from the Leon County Jail for a case management.
Sure.
I think that might work. That way you wouldn't have to go back over either. And that way it gives us time to get the matter set for a proper sentencing hearing. But we could do it by Zoom, because I can do that from the Leon County Courthouse and for a case management.
And that's, if you want to do it electronically in your JA, we'll contact us. We can figure out a convenient time if it's going to be electronic. It's totally how much time she feels like she needs to. You need 30 days before she can make a difference, or 2 weeks, whatever she feels. Do we need to set a date now, or do counsel just want to talk to Marcy and we can figure out when to get together? I'm fine with whatever. I guess we can work with Marcy. What do you want to do, Ms. Rollins?
Yes, Your Honor, we can get with your JA to
All
set
right.
up the case
All
management.
right, so I'm not going to set that case management. I know this is sitting there on my docket needing addressing, and I'll let the parties reach out. I don't have to have a case management if ultimately the sides agree on a sentencing date and work that through my JA. We don't have to have that case management, but we may need a case management just depending on what occurs.
Thank you.
With that, are there any other matters we need to address at this time?
I just ask that you remand him into the custody of the sheriff waiting sentencing.
All right, and I will note before I address that issue, Court's Exhibit 1 was the juror question, and so Madam Clerk has that and has marked it appropriately, and that will be in the record as Court's 1. And with that, the defendant is remanded, no bond, into the custody of the Gadsden County Sheriff, to the extent that he may have some sort of arrangement with other entities for the actual housing. I'll leave that up to the sheriff under his purview under the Constitution and the statutes and any memorandums of understanding he has with other law enforcement agencies. But he is remanded, no bond, pending sentencing to the custody of the Gadsden County Sheriff. All right, with that, the court is in recess.
Thank you, Judge.
So we're gonna get. And we're gonna see how long Dexter Lawson was sentenced for. I can give you a spoiler if anyone wants it. Okay, give me 1 second and we'll get right to the sentencing.
Is she now Samantha Shez?
Yeah, it's Chez. Okay, let's get started. When Dexter Antonio Lawson was 38, back in 2021, he made a few bizarre decisions. He went on his bike to a Hardee's. He then noticed that two plumbers who were riding a plumber's truck parked at Hardee's and entered the bathroom at Hardee's at the same time. Dexter walked over to the plumbing truck, saw the keys inside, and decided to steal it. He went on a joyride from Tallahassee, where he stole the truck, to neighboring Gadsden County. There was a bolo for the truck, and a Gadsden County cop eventually noticed the stolen truck and turned her police vehicle lights and siren on. The chase ended in a sort of duel. The two vehicles were facing each other in a narrow rural road. Dexter decided to ram the police vehicle out of the way so he could escape. He then proceeded to ram the truck onto the police vehicle. Doing so made the truck inoperable. Dexter got out of the truck, took a few shots at the officer, who was stuck inside the vehicle, and then he ran away. It did not take long for cops to arrest him nearby. A few locals saw what happened and went to the aid of the officer. She had been shot, but thankfully she eventually made a full recovery. So Dexter was charged with multiple crimes, and the state attorney, Jack Campbell, decided to handle the case personally. The case went to trial, and Dexter Lawson represented himself. The full trial is on this channel, and we will publish the edited version in the near future. In spite of the seriousness of the charges and the fact that a police officer was injured in the incident, the trial of Dexter Lawson was quite a spectacle. Dexter represented himself, and his main defense was that America is not a fair place and that the state could not prove beyond a reasonable doubt that it was him who did the crimes, because his head was too big, and the witnesses had not described a man with a big head had done it. In a sense, this is a real-life sequel to the awesome movie My Cousin Vinny. As noted earlier, Dexter represented himself at trial. The state was represented by the state attorney Jack Campbell. The presiding judge is the Honorable J. Lee Marsh. An attorney was appointed for Dexter for the sentencing. In this video, we show you the reading of the verdict, followed by the never-before-seen full sentencing video.
Juror number 4, are you the foreperson?
Yes.
I think you're, again, I don't have my numbers here in front of me. Has the jury reached a verdict?
Yes, we have.
Please hand the verdict form to the bailiff. Filed a null pros as to count 5, bringing us here today for sentencing. The way I like to proceed in sentencing is if the parties would like to give a brief opening, I'll give them the opportunity to do that. Then any witnesses, evidence, other matters to consider by the state can be presented at that time. Then I'll allow the defendant the ability to present any witnesses, evidence, or any other matters to be considered, including, if he so desires, a statement by the defendant to the court. At which time, I guess if there's factual rebuttal, I'll allow the state to do that. Otherwise, we'll go into argument. The state will go first, and the defense will get the last word. So with that, Mr. Campbell, do you wish to make any sort of opening statement?
No, Your Honor.
Mr. Burden?
Your Honor, it's not so much an opening statement. I would just like to put on the record a couple of things, if I may.
Okay, go ahead.
First, I'd like to note that I was appointed to represent Mr. Lawson after the trial phase, as was previously noted. I would note that normally in a situation where I was appointed for a sentencing, I would get a transcript of the trial to see what mitigating evidence may be presented to the court. However, based on the circumstances, I did not see much cause to do that here. I would, however, just like to kind of as a preliminary matter, put on the record that on Mr. Lawson's behalf, I would object to sentencing continuing and note that he had requested counsel multiple times during the trial, which was denied by Your Honor. Based on that, on Mr. Lawson's behalf, I would request that this case be set for a new trial.
All right, let me ask you 2 things about one of them. You said you'd get a sentencing transcript. Had you represented him at trial, arguendo, you had represented him at trial in this case, and we had had the same verdict, why wouldn't we have just proceeded right into sentencing anyway? He's not entitled to a PSI. And how would you have gotten a transcript between the conclusion of the jury verdict and the sentencing proceeding?
I'm sorry, Your Honor. I'm probably made that unclear. In a situation where I was appointed to represent someone after trial but before sentencing, normally I would request a delay on sentencing until I could review the trial transcript. But given the circumstances here and the mandatory penalties, I don't feel that's necessary.
All right. I would deny any continuance in that case. And as to the oral motion for new trial, the court finds no reason, in fact, in law, to depart from the previous rulings. Therefore, the motion for a new trial is denied. And with that, we'll proceed into sentencing. Mr. Campbell.
Yes, Your Honor. Counsel has I've had two exhibits marked with the clerk or pre-marked. I'd like to give an opportunity to show them to counsel if I could, Your Honor.
You may. If I may, Your Honor.
It's the pen packet. You amend discovery of the report, have to give you a copy of it. Basically, his fingerprints that down is what the testimony would be. I can proceed if you want to separate it. That's totally, if you want to talk to your client, I'm ready to go. Okay. I mean, based on the conversation, we might be able to stay in place. Okay, that's fine. No problem. Statement.
Hold on. Yes. Okay, that's fine. I'll make sure they have that. All right, thank you. All right, they didn't, Digital did not get any of the council's conversations with one another, which is fine. But Mr. Campbell, I am looking, that microphone there, the light is off. So let's make sure we hit the button there so that it, we want to make sure you're in front of a recording microphone. That may not be the one we want to use. We may want to just stay at council table, which is fine.
I can go to council table. Make sure Digital lets me know if they can't hear me. State would call Tom Balboni.
All right, Mr. Balboni, come on up. Sir, if you would please raise your right hand. Do you swear or affirm the testimony you give in the case now and hearing shall be the truth, the whole truth, and nothing but the truth?
I do, sir.
Please have a seat. State, you may proceed.
Thank you, Your Honor. Good afternoon.
Well, hold on before we do. I'll note defendant is talking with his counsel. I want to give him time to make sure he's been able to speak to counsel.
I'm sorry, Your Honor, just one more moment.
That's fine. Okay.
Thank you, Your Honor. I'm ready to proceed.
All right, go ahead and have the witness introduce himself.
Okay. Could you state your name for the record?
My name is Thomas Balboni.
Yes, sir. And where do you work, sir?
I'm employed in the Criminal Investigations Unit for the Office of the State Attorney and for the Second Judicial Circuit.
And how long have you been working for that agency?
24 years.
Can you give the court a little bit of your background and education that allows you to work as an analyst in that department?
Well, my interest in the fingerprint sciences started even before my tenure there. I previously trained with the Tallahassee Police Department in the Crime Scene and Identification Unit. There we were responsible for the detection, collection, preservation, and analyzation of fingerprint evidence at the crime scenes and in the laboratory. I attended the FBI's training course on the science of fingerprints. Since that date, I've attended numerous other basic and advanced courses in the fingerprints, palm prints, latent fingerprints, courses presented by the Florida Department of Law Enforcement, the International Institute of Identification, of which I'm an associate member under the discipline of fingerprints examiners.
And have you had the opportunity to testify in courts as an expert in the area of latent fingerprint identification and matching?
Yes.
Approximately how many times?
Prior to today, 356 times.
I would tender the witness.
Any voir dire?
No, Your Honor.
All right, you may proceed, counsel.
Were you asked by me to gather some fingerprints from a person you now know to be Dexter Lawson?
Yes.
May I approach, Your Honor?
You may.
Showing you what's been pre-marked, showing defense counsel states Exhibit 1. Do you recognize this document?
Yes.
How do you recognize it?
It has my personal notations all over here. It's written in blue ink. It has my signature, my printed name, identification, the date the prints were obtained, the location was at the Leon County Detention Facility, and the demographics of Mr. Dexter Lawson.
And what is States 1?
This is a set of inked fingerprint standards. These were collected for the specific purpose of using as a standard ink for comparison.
And do you see the person in the courtroom that you collected those ink standards from?
Yes.
Could you please indicate where he's seated and what he's wearing?
Got a gentleman in jailhouse blue sitting to the left of his counsel.
I did ask that the record reflect the witness identified the defendant. Mr. Balboni, do you have the standard inked prints on States 1 from Mr. Dexter Lawson?
Yes.
I introduce States 1 into evidence.
Any objection?
No objection, Your Honor.
Without objection.
Your Honor, may I approach?
You may.
Now showing you what's been pre-marked, showing defense counsel as States 2. Do you recognize this, sir?
Yes.
How do you recognize it?
The fingerprint page, which is page 4 of this packet of documents, is the fingerprint page, and it also bears my personal notation written in blue ink. Is indicating that this set of fingerprints were used in my comparison with the standards that I previously collected.
Have you seen packets like that one before?
Excuse me?
Have you seen packets like that one before?
Yes.
Okay. And what's the common name?
This is what we refer to as a pen pack. Others have called them time and crime sheets, but is the official record kept on file with the Department of Corrections of a specific inmate's incarceration history.
Okay. And who is this a pen pack for?
Dexter Lawson.
And is it actually under seal and have a raised and embossed seal on the second page of the certification as being
Yes.
a record under seal?
Yeah, page 2 is a raised seal, yes.
I introduce States 2 as a self-authenticating document into evidence at this time.
Any objection?
Your Honor, I would object under as not a proper self-authenticating document.
All right, let me see States 2 for ID. What's the deficiency, counsel?
Sorry, Your Honor, if I may have just one moment. I've got to pull up my note. Sorry, Your Honor. Per Florida statute 90.902, I believe the seal on that document is deficient.
All right, you wish to make further record, Mr. Burton?
No, Your Honor.
All right, the objection is overruled. States 2 is admitted.
All right. Now, actually, I'll start with, I think it's page 3. Is there an image page in that states 2?
Yes,
Okay. And do you see the image of a human being on that page?
there is a front and profile color photograph of the individual whose record this pertains to.
And do you recognize the person as in that image?
There's some similarities.
Okay. Is it the same person that you took the standard?
Objection,
prints
Your
from?
Honor. Oh, I'm sorry. Go ahead. I withdraw that, Your Honor. That was not the question I thought was being asked.
Does that image seem consistent with the same person you took the standard fingerprints from in states 2?
I believe it is.
All right, now going to 3. Did you have an opportunity to compare the latent or the standard prints, the inked prints in states 2 with the ones you collected in states 1?
Yes,
And did you do a comparison of those 2?
I did.
Okay. And what was the results of that comparison?
It was my determination the fingerprints that I obtained from Mr. Lawson were made by the same individual whose fingerprints appeared in the DOC pen pack.
And particularly going to the DOC pen pack, what is the date of last release for Mr. Dexter Lawson from the Florida Department of Corrections facility?
It is listed as 4/12 of 2021.
That's further beyond.
Cross-examination.
Briefly, Your Honor. Your Honor, permission to cross-examine from the table?
You may.
All right, thank you. Good afternoon.
Good afternoon, sir.
So the determination that the prints that you took match what you see in the document is purely your own subjective determination.
Well, I made the preliminary determination but as standard protocol, it was also reviewed by a peer employed by the Leon County Sheriff's Department for verification. That individual authenticated the verification, placed their initials and the date of that verification on both these documents.
Okay, but at the end of the day, it comes down to people looked at it and said, yep, I think those match.
Yes,
Okay, so there's no objective way of telling whether or not those were a match.
I'm not sure I understand what.
Meaning that it's simply the determination of the two people who looked at it, whether or not they match. There's nothing There's no computer program or anything that can tell you that's a match.
Well, let me state this, that even when the computer programs do determine there's a match, it is still a requirement that two humans verify the computer's finding.
Okay, so it is, at the end of the day, it is people looking at one and looking at another and saying that these have characteristics that I believe they're a match.
Correct.
No further questions, Your Honor.
Redirect.
Sure. Does latent print comparisons, I'm sorry, I keep saying that, inked print, fingerprint comparison actually require objective points of comparison?
Correct.
Okay. And are there indications that you found in both sets of prints that were unique to an individual and that allow you to make objective comparisons between those?
Yes.
Okay. Have you, in your career, made thousands of comparisons of that were not the same person?
I wouldn't say I'd made thousands of those that were not. I certainly have made thousands of comparisons that where an identification was made.
Okay. And at this point, when you make a comparison and conclusion, is that based on objective findings on the standard where you're able to say this matches this and this matches that?
Yes.
Okay. Is there, is your professional opinion that objectively the latent fingerprints and the characteristics of Dexter Lawson are found both on the standard where you collected from the Leon County Detention Facility and on the standards from the Florida Department of Correction pen pad?
Yes, and in both these instances, I was dealing with inked fingerprints as opposed to latent fingerprints.
Thanks. Nothing further.
Thank you, Mr. Balboni. If you'll hear me states 1 and 2, you may step down. State, you may call your next witness.
Your Honor, as far as the prison release reoffender predicate, which is what I was laying with that witness, the only other issue is the state would ask the court to find pursuant to 775082 that the charge of attempted murder of a law enforcement officer is a qualifying offense or a felony involving the use of or threat of physical force or violence against an individual. So that is the final thing. I just asked the court to, that's a legal conclusion. The only other presentation I have, the victim is present, and I have a victim impact statement that victim advocate's going to read on her behalf. The court's ready to receive that.
All right. Are we ready to proceed then?
Yes. That one's not really coming. You just take it.
Good afternoon. My name is Lauren Tomberlin. I am the victim advocate with the state attorney's office here in Gadsden County. And this statement is on behalf of Deputy Chikara Hearns. On November 16th, 2021, my life changed forever, and I've pushed myself countless times to try to get my life back to what I consider normal. It has been the hardest thing that I have ever tried to do, but the more I accomplish, I realize I will never go back to my normal self. I came to a realization that I had been battling since February when I became very depressed. I realized a part of me died on Jameson Road, and no matter what I do or how hard I try, I will never get that part of me back. I've been wishing and longing for just a second to be the old me, and instead I find myself laying awake, crying most nights. My stomach, left and right abdomen, altogether has a total of 10 marks, and they aren't fading away. I get up in the morning after a restless night, trying to make the best of my day, just to be sad and extremely upset when I look at my body in the mirror. My senses have heightened, and now it feels like someone is screaming at me when they are whispering. So many words and actions remind me of the situation, making it difficult to concentrate. My nerves are terrible sometimes, and when I sense danger, they don't calm down for days or months. I would rather be alone now because I feel so empty inside. It's not hard for me to express my feelings, but no one I know has ever experienced a situation to this level, so I keep things to myself. I don't have much to converse about. It always seems that I'm looked at with so much concern and pity. I'm a law enforcement officer. I'm not used to being a victim, and it's hard for me to come to terms with. At times, I feel like a robot. In a day, I've been happy, upset, cried, and depressed, and it's so mentally and emotionally straining. I don't hate you because of the way I was raised and simply because I am not God, so I don't have the right to judge you. However, I feel that no amount of years in prison can account for the amount of pain that I have felt and will continue to endure. I am a law enforcement officer, and my job is to protect and serve, but what you did was completely senseless. Out of everything that happened, there's one thing I cannot get out of my mind. Why did you turn around and start shooting at me? You had the ability to be so far gone. I was stuck in my patrol car. You didn't have to do that. You asked me when I was cross-examined if you thought you deliberately tried to kill me. And after much thought, I believe you did. I think you came back and shot at me to finish me off completely. You apologized to me, and I cannot and will never accept your apology. I will say that this situation has definitely showed me that I am very strong and determined. I am still going to protect and serve and treat people with the utmost respect. I will forever be humble and God-fearing, but most importantly, I will not allow this situation to box me in a corner and stop me from living up to my full potential. Sincerely, Chikara Hearns.
That's all of the evidence, testimony, or I have argument. I'm happy to do that now. I can wait for the defense.
We'll wait for the defense. All right. Defense, any witnesses or evidence you wish to present?
None except for Mr. Lawson if he chooses to make a statement,
Okay,
Your Honor.
and I'll give you a moment to speak with him about that.
Your Honor, Mr. Lawson, after consultation, does not wish to make a statement at this time.
All right, Mr. Lawson, you and I are going to talk about that much like we did with your right to testify. You had the absolute right to address this court prior to this court announcing a sentence in this case. And that's your decision and your decision alone. It's not your attorney's decision, but he's going to give you the best legal advice that he feels he needs to give you. That being said, this court will not hold it against you if you choose not to address this court. That is your right as well. So knowing those rights to address or not address the court, it looks like you need to talk to your counsel.
Yes, Your Honor. Your Honor, after further consultation, Mr. Lawson would like to address the court.
All right. Then with that, Mr. Lawson, the floor is yours, sir.
All right. First and foremost, one thing about the past, you can't take it back. But one thing that I know for sure is life more goes on, right? And it's been things that I've been going through as a person, as an individual. I've been on psychotropic medication since I was 23 years old. Like I'm still on psychotropic medication now, right? I hear voices, I see things. I got suicidal ideation, homicidal ideation. So as far as with her, on her behalf, right? I don't even know how you look. I don't even see you, period. Like I don't even remember this episode. The only thing I remember is the video. Okay, I wasn't mental health evaluated properly, but at the same time, okay, for me to go through the process that I'm going through is unfair all around the board because for one, I wasn't evaluated mental health properly. You know what I mean? But only God can judge me, and thing is, God don't make no mistakes. God make all plans. So the fact that I'm here and everybody here is God doing all around the board. So like mental health is a real thing. Like I've been getting locked up since I was 12 years old, like back and forth. And I done been out 7 months and I wasn't on my medication. And the situation that inspired has nothing to do with nobody but me. You know what I mean? Because I've been facing a demon inside of me. Like it wasn't nobody but me. So God don't make no mistake. He make all plans. So like, you know, a lot of people ain't here today. Like I know a lot of people ain't here today, and that's no mistake. That's a plan. So if you here, man, like that's all that matters. Like that's all I gotta say.
Thank you, sir. Mr. Burton, any further witnesses or evidence you wish to present?
Nothing, Your Honor.
All right, what I don't have, folks, is a score sheet. Mr. Campbell, do you have a score sheet?
I do, Your Honor. May I approach, and I've shown a copy or provided a copy to defense counsel and defendant. I filled out the dates on it, Your Honor. Otherwise,
Give me a second. I'd like to take a look at it before we go into argument.
yes, sir.
I see there was a motion for competency. Was that completed?
Yes, sir.
Okay. I don't have any record of it, so again.
Okay, sure. It was done right at the beginning. Dr. Blandino authored a report finding that he was competent.
And counsel, I'm gonna speak about that.
Okay.
Before issuing the sentence. So just give me a minute.
Your Honor, we're ready to proceed if you're waiting
Okay.
on us.
All right, any objection to the proposed score sheet?
Your Honor, I've reviewed the score sheet and defense has no objection.
All right, so before we go into argument, I want to call counsel's attention to Florida Statute 921.0024. One, it looks like, or B, is it? No, it's not one, but 921.0024.2, which states if sentencing points are greater than 363, the court may sentence the defendant to life. Would that apply to all four counts in this case?
Yes, Your Honor. The state's position would be that because the score sheet's in over 364 sentencing, we could sentence him, court could sentence him to life in each count. The lowest permissible would be 500, I'm sorry, I give you a copy of my score sheet, but whatever the lowest permissible.
415.875 months.
Okay, so that would be the lowest permissible, and there's clear case law that says that when that is greater than the statutory maximum, that it can exceed. I understand the court's point, and yes, sir, the state's position is that you would be able to sentence it to life throughout. Perhaps it's cleaner if you did it just on the 2 life sentences, and once again, I'll hold that to just to argument.
All right. And Mr. Burden.
And I'm sorry, Your Honor, I just need to review this statute for a moment. All right, Your Honor, as I read the statute, whereas it says, if the lowest permissible sentence under the code exceeds the statutory maximum, the sentence required by the code must be imposed. That is the score sheet. It then simply says, if the total sentence points are greater than or equal to, the court may sentence to life imprisonment. I do believe that is, however, bound by the statutory maximums. I don't see anything in the statute that holds that the score sheet points being over 363 would give the court the ability to exceed the statutory maximum. I do not doubt, right? I do not dispute that you would have the discretion to sentence life as to anything that, any statute that allows that. For example, in this case, the 2 counts of attempted first-degree murder of a law enforcement officer.
All right. With that, I'll hear argument on sentence beginning with the state.
Once again, Your Honor, the state's position is that if there was ever a case that deserved life sentences as this, we have went ahead and laid the foundation evidentiary. The state first would ask the court to find that he does qualify as a prison releasee reoffender, specifically under Florida statute 775082. Attempted homicide is a qualifying offense, and it's clearly a crime of violence there. So as such, if for no other reason, but the fact that clearly that this happened within 3 years of his release from the Florida Department of Correction, based on the testimony taken today. So the state would, ask the court to make that evidentiary finding as part of sentencing. I understand the redundancy based on 782065, which also requires for count 1 and 2 mandatory life imprisonment for each attempted murder of a law enforcement officer. Finally, when you look at the fact that this defendant's been in prison 6 times now, has 15 felony convictions, at least 12 felony convictions just with what he's gone in and out of prison. And then you have the outrageous conduct of the defendant in this case. All of that suggests to the state that this is a time for a maximum sentence. So the state would ask that that the court find that he's a PRR, sentence him pursuant to that on count 1 and 2 to life consecutive to one another, both as a PR and pursuant to Florida statute 782.065, which also requires life imprisonment for the attempted murder of law enforcement. The jury specifically made the findings with the interrogatories that she was a law enforcement officer in the scope of her lawful duties, and that he knew her to be such. I can't really say anything much more poignant than what she said in her victim impact statement, Your Honor. The court had the opportunity to see his entire presentation in the trial, and the state's position is that he's had a fair trial. He is competent based on the results of the doctor, and has always been competent through this proceeding. And now that the state would ask that you sentence him to 2 life sentences consecutive, and then life sentences on counts 3 or 4, or in the alternative, I would ask that you say that if it's inappropriate to do life, should the future court decide it, that you sentence him to the lowest permissible on those 2 under the score sheets consecutive to one another. The state's position is that the balance of Mr. Lawson's life must be spent in the Florida Department of Corrections. He has proven to us that he will kill, and we will not need to give him another opportunity to do it again. Thank you.
All right, defense, you may argue.
Yes, Your Honor. I begin by putting on the record, just so it's clear, Mr. Lawson is still contending that he was not competent and that a proper evaluation was not done. He also contends that there were discovery violations by the state in the course of this that affected his ability to have a fair trial. Again, Your Honor, I was appointed after the fact. I have not had the opportunity to review any sort of trial transcript, so I'll put those on the record so Mr. Lawson's objections can be noted. On my behalf, I would object to Your Honor sentencing him under the PRR statute. First, I would hold that the state has not successfully proven that he qualifies. In addition, I would hold that the PRR system would be a violation of the Constitution, specifically Amendment 8, forbidding cruel and unusual punishment. I would also, for the record, object. I believe that a life sentence without parole in any circumstances violates the Eighth Amendment for cruel and unusual punishment. Beyond that, Your Honor, defense would ask, Your Honor, if you feel that life is necessary to run counts 1 and 2 concurrent with each other for a concurrent life sentence. In addition, we would ask for...
Hold on, counsel, before we get there, as it relates to concurrent, what about 775-087, the firearms provision? Doesn't that require consecutive sentencing based on the special finding of this verdict, of this jury as to the firearm?
I'm sorry, Your Honor, what statute is that?
775.087. It would look like this one's got a mandatory, well, it's got a mandatory life with a mandatory minimum 25 years, at least as to count 2, and that is to be served consecutive with count 1 based on the 775.087 as well as the jury finding. And I want the defense's position on that.
So, Your Honor, my reading of the statute is that the consecutive would only apply to the charges coming under the 1020 life or a firearm statute. Let's see, I'm sorry.
Right, so why wouldn't that?
My understanding is that of the 2 counts, 1 was not firearm related.
Correct.
So, Your Honor would have the ability to sentence him to a life sentence for the firearm and then a concurrent life sentence based on the non-firearm offense. If I'm reading my reading of the statute, Your Honor, I'm reading Florida Statute 775.087 subunit D, which specifies that the court shall impose any term of imprisonment provided for in this subsection consecutively to any other term of imprisonment imposed for any other offense, meaning that you could impose as the firearm a life sentence which meets that, and then you can impose a life sentence concurrently based on the non-firearm offense.
How do I impose concurrently when it says the court shall impose any term of imprisonment provided for in the subsection consecutively to any other term of imprisonment? Doesn't he have other terms of imprisonment, specifically count 1, count 3, and count 4? Doesn't count 2 have to be under subsection D? Doesn't it have to be consecutive? I get where you're saying that 3 and 4 could be concurrent with count 1, but I'm not seeing how it's concurrent with count 2. Again, I know the position you're in, but the extent is to what the statute says, vice, the desires of this defendant and and the position by which you find yourself in this case, having come in when the jury has already rendered a verdict?
Your Honor, I would just stand by my argument. I think the court has the ability to sentence him to the firearm, to a life sentence on the firearm, and then to concurrently sentence a life sentence. I'd also point out, Your Honor, it is a life sentence, whether it's consecutive or concurrent. I mean, I understand the paperwork has to be correct, but I think we're well in the weeds chasing after, or just well in the weeds at this point.
Well, unless something happens on appeal and they find you didn't show the law enforcement language, and all of a sudden it's no longer, and it's, does he get credit for this one or not for that one? Because I would assume that there are going to be appeals in this case, and I would assume that counsel is going to put forth whatever legally appropriate argument is, attacking anywhere they can, as they're going to zealously represent Mr. Lawson in that, and that, heaven forbid, well, not heaven forbid, I mean, that's the law. If it's there, it's there. If it's not, it's not. That's our system. But if an appellate court were to find some issues, it affects whether he gets credit for certain time, et cetera. So at the end of the day, yes, as we sit here now, it would seem like we're chasing it, but we've got to understand the appellate nature of our system, that it seeks to protect the rights of defendants until finality of the case.
Yes, Your Honor.
Whereas I get there's limited opportunity on a 3.850, but even in that, when we think something's final, our appellate courts have said they're not quite final yet. So understood. Okay.
I would just stand on my argument that I believe my reading of the statute is that you would have the ability to sentence to a life sentence for the firearm count, which would satisfy that statute, and then you could run other counts concurrently.
All right.
I'm sorry, Your Honor. Finally, Your Honor, I would just ask you to consider, you heard from Mr. Lawson today, he suffers from mental health issues. He has suffered from them for some time. He's been on psychotropic medications for most of his adult life, well, all of his adult life and a good chunk of his life period. I would ask you to take that into consideration when making a determination.
All right. Now, it looks like, and I'll ask folks, it looks like as far as credit for the time that he's served, it looks like he was first arrested, at least technically arrested, on a Leon County grand theft of a motor vehicle on November 16th. The Leon County subsequently dropped that case. It was subsumed in this one based on the crossing of the county line with the vehicle. Gadsden County then proceeded. And I'm trying to see was he ultimately arrested on counts at least 1 through 4 in this case on the 16th, or was it not till the 17th? Should we just give him credit for since the 16th of November 2021?
My suggestion is just give him credit from the date of the incident. He's been in custody throughout, and so I want to give him every day he's earned. So I'm giving the calculation right now.
It looks like 307 days, if I've gotten that right.
That's what I had in my calculations, Your Honor.
And is the state asking for costs of prosecution?
It's required by law. Yes, sir. We are.
May be required, but I also know that there are appellate attorneys out there that do their job and are required to say if the state hasn't asked for it, then I'm not allowed to award it.
Yes, sir. No, the state's asked for cost of prosecution on this case, Your Honor, $100.
Your Honor, defense would waive the cost of defense. We'd also ask any monetary fine be civil judged.
All right, the court makes the following findings. The defendant was previously released from the Florida Department of Corrections on April 12th of 2021. Then on November 16th of 2021, he was arrested for having committed, and a jury did find he did commit attempted first-degree murder of a law enforcement officer, 2 counts. The court finding these requisite charges under the prison releasee reoffender statute of crimes of violence, and the time of since last release less than 3 years. The court finds this defendant is the one and the same, that is states 1 and 2, and based on states 1 and 2 that he is a prison releasee reoffender. Accordingly, the court must also address a couple of other matters from this case in the sentencing proceedings. The first is during the cross-examination of Mr. Tom Balboni, the defense opened the door to what would otherwise be the inadmissible bolstering of the fingerprint witness, in this case, Mr. Tom Balboni. The court will note the state did not solicit input that this was verified by a second person. Normally that would not be allowable. However, the court finds that defense opened that door in regards to it was only he that decided that, thereby allowing the redirect, allowing the response on cross as well as the redirect concerning a second person verification, which was done in cross-examination on the redirect on objective comparison points. The court will also note that the defendant brought up during his statement to the court an issue regarding his mental health. This court will note that this court very early on in the process ordered a mental health evaluation, in this case a competency evaluation, that there was a motion filed very quickly based on a series of recusals and assignments and requests for Nelson hearing. But when this got before the court ordered said competency hearing. That hearing was conducted by Dr. Salvatore Blandino with a date of evaluation of April 5th of 2022, a date of report of April 13th of 2022, in which Dr. Blandino spoke with the defendant at length, indicating unacceptability as to certain questions. However, in doing that, Dr. Blandino looked over the various I don't know, I don't remembers as quite suspect. Accordingly, he went question by question, giving numerous multiple choice answers to questions that had an obvious correct and numerous incorrect answers, such as when questioned if the outcome of being found guilty entailed being sent on vacation, being given money, being set free, or being sent to prison, Mr. Lawson replied, vacation. Similarly, when asked if the outcome of being found not guilty would result in one being set free, locked up, winning the lottery, or being killed, Mr. Lawson replied, killed. When questioned as to the title of his attorney being the public defender, the state attorney, the King of England, or Bozo the Clown, Mr. Lawson replied, Bozo. When questioned as to the title of the state attorney being a public defender, state attorney, Cleopatra, or Tupac Shakur, Mr. Lawson replied, Tupac. There are numerous other questions that the examiner asked. The examiner also administered the ILK to Mr. Lawson. That's a 61-item true-false used by forensic examiners to look at a number of areas. Mr. Lawson scored a score of 9, which according to the ILK manual, score less than 24 considered to be significantly below the ranges of scores that are expected to occur by chance and provide compelling evidence of a feigned response style. The court will note that during the conduct of this hearing, the court spent many hours in the presence of the defendant. And I said this during the course of the trial. He was nothing but polite. He behaved appropriately, whereas he was not necessarily learned in the law. He made numerous cogent arguments, both to the court and to the jury regarding absences of evidentiary pieces that would, in his argument, or reasonable doubt as to the state's ability to prove this case. Again, he didn't deny any of this happening. He said that the state could not prove it beyond a reasonable doubt. He pointed out the lack of DNA. He pointed out the fact that the victim in this case, that this survivor was unable to eyewitness identify him, and he pointed out other numerous appropriate legal arguments, ones that this court would have expected an attorney to make. Accordingly, again, the court finds that the court will also note, I saw him extensively during this trial. Throughout, there was no indication of the defendant responding to any kind of internal voices, speaking to himself, reacting to internal stimuli, and there's no indication of him being improperly diagnosed. So the court finds the defendant remains competent. As to a discovery violation in this case, the court will note that the file will speak for itself as to the steps taken by the state attorney to provide documentary evidence to this defendant. There is plenty on the record that I will not rehash now regarding videos, etc., but the defendant was able to see those here in the courtroom. And the court will also note this court received no motions to compel, no indications of discovery violations pre-trial, and this defendant requested a speedy trial. I use that phrase purposely. It was a request, although he indicated a oral demand. The court will note that the rules of criminal procedure require a demand for speedy trial be in writing, but this court took great pains to give him exactly what he desired, which was a speedy trial. And accordingly, the court finds no cognizable or non-waived discovery violations. As it relates to sentencing in this case, the court sentences the defendant as follows: to court costs of $418. And hold on, folks, I've got to give the statutory basis, which is not on my little sheet here. I'll pull one up. Give me a moment.
Yeah.
Do you have it broken down? Because Leon's is different. Okay. Yep. Okay. Yep. No, this is exactly what I'm doing. All right, the court sentences you as follows. To a fine of $175.28 pursuant to 775-083. A fine pursuant of $20.50 pursuant to 142.01. 5% surcharge of $9.22 pursuant to 938.04. $20 court cost pursuant to 938.06 Crime Stopper Trust Fund. $3 court cost pursuant to 938.011 Criminal Justice Trust Fund. $50 pursuant to 938.03 Crimes Compensation Trust Fund. $225 pursuant to 938.05 Local Government Criminal Justice Trust Fund. Unless somebody can give me the county code, I'm not having this come back on an illegal sentence on a $2 charge, so I'm not going to do the county criminal justice education. I won't impose that. $50 court cost pursuant to 775-0832 County Crime Prevention, and $65 court cost pursuant to 939.185 County additional. No, I'm not doing any of those county codes without that. I've seen them come back too many times where I've got to correct them based on not having the county code, so I'm not going to do those. Same thing with teen court. I'm not going to do those. I'm just going to do the state ones. All right. As to count one, this court hereby sentences you to a term of life in the Florida Department of Corrections. As to count two, this court sentences you to a term of life in the Florida Department of Corrections with a mandatory minimum of 25 years. As to count three, this court sentences you to 415.875 months. And as to count four, this court sentences you to 415.875 months. Count 1 will run consecutive to count 3. Count 2 will run consecutive to count 1, which is consecutive to count 3. And count 4 will run consecutive to count 2, which runs consecutive to count 1, which runs consecutive to count 3. The court finds factually distinctive separation in these 3 crimes, despite the fact that the 775.087 requires the consecutive nature as to the firearm charge. The court will note that this was started out by a grand theft of an automobile. Then the defendant, in ramming his vehicle into the vehicle of this survivor and driving her back over 102 feet, committed the next crime. The court will note it's factually distinctive then that he ran away from the vehicle in question and then ran back, thereby shooting 6 shots, 3 of which struck the survivor in this case, making it a third very distinctive crime. And then he ran away, and as he was running away from this crime scene was attempting to get rid of physical evidence, thereby tampering with that physical evidence, another factually distinct crime, and the court finds consecutive sentencing to be appropriate. This court chooses not to, although I was tempted, chooses not to sentence him to life on counts 3 and 4. I see no need to expend the judicial resources in litigating that. The court will save that for another day and another crime. The defendant will receive 307 days of credit as to count 3. The others being consecutive, he will not receive credit in those. With that, are there any other matters that need to be discussed?
No, Your Honor.
Your Honor, I'm sorry. I just want to make sure I get this. I believe he is entitled to the credit already served in the case, in the charges, even if they're running consecutive. I believe it's just new gain time that he would not pick up. But I believe he's still entitled to the time he's already spent in custody on all counts.
The state believes the court correctly, once again, he gets credit, but by sentencing him consecutively, the court, I believe, has appropriately done so.
Yeah. I'm only giving him credit as to count 3. You can file any motions needed.
I understand the ruling, Your Honor. I object for the purpose of the record.
And the court will inform the defendant, sir, you have the right to appeal within 30 days. If you cannot afford an attorney, I can appoint one to represent you. Mr. Burden will be able to assist you in those discussions about your options to appeal and help prepare that appeal, at least to the extent of getting the notice filed and any requests for counsel. And then we'll see where it goes at that point. There's a whole process by which the court will then look at.
Your Honor, I would just ask, since I am coming in and my office is coming in only on sentencing, I do not have a particularly strong grasp of everything that may have been at issue when it comes time for the judicial notice. If we just write in any judicial acts, would the court find that sufficient given the lack of specificity?
I don't have a problem with that. And then the appellate counsel can comb through this record and see what was preserved and what was waived and go from there.
Yes, Your Honor.
All right. Thank you with that. What? Is say? Yes, count 4 is the initial count. Count 1 is consecutive. Hold on, folks. Count 1 is consecutive to count 4. Count 2 is consecutive to count 1 and thereby operational law count 4. And count 3 is consecutive to count 2, is consecutive to count 1, is consecutive to count 4. Say again? Count 4 is consecutive to, actually it's consecutive to count 3, or excuse me, 2. It's in order that they're to be served is 3, 1, 2, 4. With that, the court is in recess.
Thank you, Your Honor.
Actually, before we go into recess, the court make sure the defendant will be remanded to the Department of Florida Department of Corrections for the remainder of his sentence.
Hey, it's Ladybug back again. I hope you enjoyed the entirety of Dexter Lawson's trial. We will be posting some highlight videos on Deep Dive True Crime, so those will be coming out soon. And let us know your thoughts of how Dexter did throughout the trial. For someone who has no clue, I didn't think he did as bad, but he was obviously incredibly comedic and fun to watch.
I think he was a highlights machine, honestly.
Yeah, he's definitely going to have a lot of highlights on Deep Dive, so that's coming out. Make sure you have your notifications on so you can always see when new stuff, and the goal is to do more trial lives with all of you, especially those of you who love trials, so this will be more of a weekly thing, depending on time and work and all of that. But
Some of them will be completely new trials that have never been published before.
So they won't be something you've seen. Everything will be brand new. So thanks for watching with me and Mentor Lawyer. We'll see you next time. Bye-bye.